gentleman yields back. Questions on the amendment offered by the gentlewoman from California. Those in favor say aye. Aye. Those opposed say no. No. Depending on the chair, the noes have it.
Recorded vote.
Pursuant to Clause 6 of Rule 18, for the proceedings on the amendment offered by the gentleman from California will be postponed. It's now in order to consider amendment number 5, printed in House Report 113-476. For what purpose does the gentlewoman from Wisconsin seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will designate the amendment.
Amendment number 5, printed in House Report number 113-476, offered by Ms. Moore of Wisconsin.
Pursuant to House Resolution 629, the gentlewoman from Wisconsin, Ms. Moore, and a member opposed. Each will control 5 minutes. The chair recognizes the gentlewoman from Wisconsin.
Thank you so much. My amendment is really rather straightforward. It preserves the ability of the Consumer Financial, Commodities Future Trade Commission to regulate derivatives markets while maintaining the reasonable cost-benefit provisions that are already in the law. Just to give you a little history, Mr. Speaker, as we know, unregulated derivatives transactions in 2008 precipitated the 2008 financial crisis, from which this country is still struggling to recover. Section 238 is not something, as I have heard earlier in this debate, that will just make it more facile for manufacturers or for end users or farmers. It's a Trojan horse designed to deregulate derivatives markets by providing Wall Street favorable terms and means to sue and overturn laws and regulations, not on substance, not even on congressional intent, but by challenging economic studies in court. Regulatory gaps in derivatives regulation will put taxpayers back on the hook for Wall Street excesses. Mr. Speaker, I would like to enter into a record an analysis that I did. It was posted in the Huffington Post. GOP cost-benefit bill benefits Wall Street, costs Americans.
I'm sorry, that must be entered in during general debate of the full House.
Unanimous consent I ask for. Thank you, Mr. Speaker. Regulatory gaps will put taxpayers back on the hook. I can tell you that the requirements of this new Section 203 is a mandate for regulators to consider available alternatives to direct regulations. Alternatives to deregulation? What are we talking about here? As a member of Congress, and all of us who are accountable to voters, we should not be comfortable passing laws only to have regulators not implement them because Wall Street hedge funds or swap dealers object to a cost study issued by the regulations. The wolves of Wall Street should not get a veto over regulations because they produce a self-serving study that a regulation may or may not may burden him in some way. Mr. Speaker, how much time do I have?
The gentlelady has 2.5 minutes remaining.
2.5 minutes?
2.5.
I'd like to reserve my time.
Gentlelady reserves. For what purpose the gentleman from Texas seek recognition?
I rise in opposition to the amendment. Claim the time.
Gentleman from Texas is recognized.
Well, thank you, Mr. Chairman. Mr. We've already talked at length about the benefits of cost-benefit analysis, and the Section 203 would bring the discipline necessary to the agency for them to consider the costs and benefits when prescribing a new rule or regulation. The gentlelady's remarks would be much more in line if she was strictly asking to strike the section, but she's asking for a study or sense of Congress. Why would we need a sense of Congress based on her arguments that CFTC doesn't need this issue at all? And I would understand her arguments a lot better if she had simply asked for a strike. I'm going to oppose the gentlelady's amendment because it too is a stalking horse. Her amendment is a stalking horse because it would simply replace the bipartisan, well-crafted consideration for the new cost-benefit analysis for the CFTC with a sense of Congress. And that, in my view, would gut and negate the value of having the agency actually go through, as they make a rule, as they propose a rule, to determine what will it be the cost and what will be the benefits. We're always going to have regulations. God started us off with 10, and we're going to have regulations. But they ought to make sense. They ought to regulate the minimum amount that's needed to regulate, and when they expire, when the usefulness goes away, then they should expire as well. So as an agency conducts that process, taking into consideration the costs and benefits is an appropriate step as they put together regulations. It doesn't mean that the cost-benefit analysis will control in every instance, but it does allow for a better sense that those who are being regulated here have their voices heard during the process, and then if they've done it, if the agency a proper cost-benefit analysis, those who are regulated will stand a better chance of voluntarily comply with those new rules, will have less acrimony during the process, and perhaps even less litigation if the agency would use a proper cost-benefit analysis and reflect that impact of that analysis in the rules. And with that, I will oppose the amendment, and I reserve the balance of my time.
Here's a gentlewoman from Wisconsin.
Thank you, Mr. Speaker. You know, those bipartisan groups who do not learn from history are doomed to repeat it. And we, on a bipartisan basis, didn't regulate these derivatives, and we will unfortunately learn our lesson. I would like to yield time now to the ranking member of the Financial Services Committee, Ms. Waters, whatever time she might consume.
Gentlelady from California is recognized.
Thank you very much for yielding additional time to me to talk about cost-benefit analysis. I think the gentlelady has made a real case for what we're dealing with here. First of all, we know, and I guess we all agree, that prior to the meltdown that we had that caused a recession in this country, that we did not have the kind of oversight that we needed on derivatives. And we worked very hard to bring about transparency. We worked very hard to get a handle on the role that derivatives had played in this meltdown that we had that caused us almost to go into a depression. And here we are trying to implement the reforms, trying very hard to protect the American public and those end users that have been talked about so much today. And cost-benefit analysis is just another way that have been injected into this whole attempt to regulate that would place unreasonable burdens on the CFTC and basically prohibit them from doing their job. The gentlelady, in offering this amendment, has made it very clear, and she's added additional support to what we've been talking about today relative to cost-benefit analysis. And so I hope that not only the information we're presented, but the information that she's presented is enough to have people understand what we need to do in order to protect the CFTC's ability to do its job and to carry out its mission. And I would yield back to the gentlelady.
How much? Gentlewoman from yields back. You reserve. You have 15 seconds remaining. 15 seconds.
Wow. I will. He has a right to close, so I'll take it. You know, Section 203 takes us back to the day before AIG melted down. We're moving backwards in time and not forward with strengthening our economy. And with that, I would yield back.
Gentlewoman yields back. Gentleman from Texas.
Thank you, Chairman. Mr. Chairman, throughout the debate on this bill, in committee, in subcommittee, throughout this thing, we have made the point over and over that this is simply a prospective change to the rules for the Commission. It has absolutely nothing to do with the rules that are already in place. The 60-some-odd rules that are in place to